purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency, as alleged by the petitioner against the first respondent, has not been established. In other words, both the mens rea and actus reus of the Act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on his claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate, that after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore, in my view, the requirement to conduct a fresh primary election does not apply to the nomination of a vice presidential candidate. Thus, my Lord of GJC highlighted this point in its one as follows. The fourth respondent was not required to buy any nomination form. He was the second respondent, APC's candidate, at the election into the office of Senator representing Borno Central District. But before the election could hold, he was nominated as the third respondent's associate, who is to occupy the office of vice president. The fourth respondent did not buy a nomination form for the said office, and most importantly, did not contest any primary election in order to emerge as APC's vice president candidate. Close of court. The petitioner in paragraph 28(2) of his petition had averred and also contended in his final address that there was a gap of about 3 weeks between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent because the candidate of the third respondent had lapsed and was no longer in a position to constitutionally nominate a running mate. This contention of the petition is, however, misconceived. There is nothing in the Constitution which robs a presidential candidate of his right to nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 would not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition is held to be devoid of any merit. Well, we'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as an elderly person, I know what is going on.
My Lord, we're just wondering, sir. We just wondering, my Lord, if your brethren agree with your judgment or not.
Pardon?
I said, we're just wondering.
So it's a consolidated judgment. They will give their contributions after we have read all the judgments.
Oh, my Lord, yes. Please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my Lord. Thank you, sir.
Call the court.
True.
Well, so far.
The first part. Well, we can't tell at this time if it's the first part, but first part of the proceedings has just gone underway.
Well, what the justice said was that's the fourth item, so to speak. So there's still the third one, there's the second and the first.
And the first.
But the reason they're taking them all up together is, according to the justice, they are consolidated. In other words, they are all related one way or the other. You'll see that a number of times he would say, look, as we had previously mentioned, it's a pre-election matter. As previously mentioned, it's a pre-election matter. But at least one thing can be said clearly now, that this court has struck out APM's suit against Shettima and Tinubu for lack of merit.
Merit, yeah.
For the preliminary objection, the court held that the petitioner, that's APM, ought to have filed the case before the Federal High Court within 14 days from the course of action, from the day of the course of action arose. The court agreed with the respondent that the issue is statute barred. And consequently, the justice who read the leaked judgment added that Section 285 sub 14C does not allow members of any political party to challenge the nomination of candidates of another political party, and consequently declared that the petitioner lacks the local standing to institute the petition.
And recall that the PDP did indeed take the matter to court as a pre-election matter, and the Supreme Court held that there was no double nomination. So on this case, the judge has ruled that the petitioner failed to prove that the third and fourth respondent failed to prove that they were not validly nominated. And on that strength, it's been struck out for lacking in merit.
It's a long haul. We're still, this is pretty much, as we have been informed, the long haul.
Long haul mean by implication.
Yeah.
We could be here for another 2 to 3 hours, so to speak. But, in response to one of the council's inquiry just moments ago, Justice Samani may have said that, it's a contributory judgment. I wonder what's the implication of that. Is it that it's a contributory judgment from all of the other 4 justices, or will there be a dissenting judgment?
Well, I guess that's what we would wait to see, because, if you recall what Mr. Kwek has told us the other time, as well as Dr. Otitoju in Abuja, that, look, a lead judgment could take X number of hours. And if you also recall what the justice said to us, this is just the judgment. There are other arguments in it. You have to get it later. I'm like, okay, so this whole conversation started sometime around 10 o'clock?
9:27 to be precise. I took note of the exact time that the judges walked in. But, just also warn you that Senior Advocate Morrison also said that in case there's a dissenting judgment, that could also take some time. Yes, yeah.
So there is contributory judgment, there is dissenting judgment.
We do not know for sure.
I don't know. This is what makes, that's why maybe I should ask senior journalist of Nigeria and senior advocate of journalism, but no, that's Chamberlain and Sheon, because they went to town on the case the other time as well. But I guess we'll wait to see the very appropriate time. The court is taking a bit of
a break,
leg stretching break. The justice said 15 minutes, and he said, going by the ages of the people who formed, yes, he knew what it meant.
Justice Samani indeed noted jocularly, that Mr. Uzoku, Senior Advocate of Nigeria, was up and about due to age. So it was just a good time to take a break.
Well, and that's actually humane, the fact that we have work to do does not mean that we shouldn't be sensitive to the issues. So I guess that's 1 down, 3 to go so far.
You were talking about senior advocate of journalism. The senior advocate of journalism in Abuja was telling us earlier that there are 3 main hinges upon which the judges always rule. The strength of the case, that's the strength of the argument, the facts of the matter, and evidence, tendered before the court. And we're seeing that play out in the first, of the many items before the court today.
See why I called him senior advocate in journalism?
Yeah.
Okay. So we'll take a short break in a moment or two, just to let you know that any moment from now we will continue with our broadcast of this. And as we mentioned to you, we've been trying. Oh, by the way, we could also inform you that not a few issues are trending right now on X about this particular case. Number one, a PEPT judgment is the number one hashtag right now. 25% in FCT is also trending. Justice Samani earlier trended, I think, number 3, but now he's trending quite down the ladder, at least about number 9 or so right now. And a number of other trends. Presidential Tribunal is also trending, and several others like that. So just so we know. And
also to inform you that during the first part of the proceeding, just before the break, we had more than 24,000 views.
More than 46,000 on our dedicated stream, but we have others all numbering up to about between 4,000 and 5,000 on X watching this live broadcast.
And I believe senior advocate of journalism on the other end in Abuja, Nyota, wants to weigh in on the matter. Nyota, are you there now?
Well, I'm not sure that he is, but let's see. Most certainly when he is, he will most certainly be brought in to have a conversation with us on the matter. So we need to take a little bit of break in a moment or two, but just to let you also know that the court, the Presidential Election Petition Court, has declared that as at this moment, APM suit against the Vice President Shetima and President Tinubu has been struck out for lack of merit. The critical case made was that, look, this is supposed to be a pre-election matter and consequently should have been dealt with within 14 days from the day the course of action arose.
Actually, Ayo, we surpassed the 46,000 mark. I think that was the last time we checked. The update now is that we hit 70,000 views at the peak of the proceeding during the reading out of the judge's ruling by Justice Haruna Samani.
See?
Yeah, 70,000. And we're bound to surpass that when there's a resumption of the continuation of proceedings, when the judges begin to read the ruling from the other petitions.
But at this moment, maybe because of the break, we've come down to 59,000 watching as we speak. And that's just for one of our views, as we've mentioned to you earlier. We have 2 other streams that are doing about the same thing. So, well, as I'm being corrected now, someone is saying that the journalistic equivalence of SAN is SAP, Senior Advocate of the Pen. Well, I guess we'll come back to that some other time. So if we can take a short break, and we'll be right back with you to take on more of that. Don't forget, so far, the decision of the court remains that the APM suit against the president and the vice president have been struck out for lack of merit. And the court has said it's something that should have happened at least 14 days within the time it happened and the cause of action that should have arisen. We'll be right back.
Nigerian Police Force has diligently emplaced all necessary deployments and security measures during this critical period, as officers and men are fully prepared to maintain order and enforce laws while respecting the rights and freedoms of all citizens. Furthermore, the Nigerian Police Force strongly cautions all individuals, including mischief makers and political gladiators, to be cautious in their actions and statements, as the force will not condone activities capable of inciting violence or causing a descent into anarchy. It is imperative for all citizens to embrace peace and maintain calm, regardless of their political affiliations, to ensure a peaceful and secure environment.
Well, in another 20 minutes, it'll be 12 o'clock. So still some time to get the rest of the balance of judgment. But as you can see, my colleague, Shola Shoyele, is standing by right there at the tribunal, well, the PEPC, Presidential Election Petition Court, to give us an update. Shola, good morning. How's it been so far? We've received some reports from you. Hear exactly what you're saying to us, but well, as you can see, she's standing by right there, and she's going to give us a live update of what has been happening so far. As we mentioned to you earlier, the formerly named Twitter, X, is agog with a lot of trends about this particular issue. And as we have told you, the justices said, look, we're going to take a short break of about 15 minutes to do the needful and then come back to us. Well, you mentioned Nyota the other time. Nyota is also right there in Abuja. Hopefully he will have a couple of people to speak to us. But for now, just to give you that update, that expectations are high. And it's also instructive what the police spokesman mentioned earlier, that every one of us should recognize that we have one nation, that we must prioritize its interests. Everyone who is agitating one way or the other, we definitely love the country Nigeria. That's the reason we're doing everything that we are doing. So now that that is our reality, our words, our thoughts, our deeds should be guided in that reaction.
Absolutely. Even though civil society has advocated, before now, just hours before today's ruling, that the right to protest, by the civil society should be respected. But amid all of that, we must prioritize the stability of the polity above all other interests. So if there will be any protest should be done responsibly without any violence.
Absolutely.
Every agitation must be ventilated responsibly. Because
it's for the love of country that every one of us is doing what we are doing, and that should be the major thing. Well, you asked for Nyota the other time. Well, he's also, should I say, sitting by, ready to take this on. So Nyota, so far, so good. 1 down, 3 to go.
I was actually looking at the trends, and I noticed a couple of things that are really, really trending. For instance, it appears all of Nigeria is watching, and on all the platforms. Yes, a lot of people are watching what we're doing here on mainstream television. Some are watching via live stream on the different platforms. We're streaming on Facebook, YouTube, and all of that. But looking at the trends on X, I see that the Supreme Court has about 137 posts. Top trend, 134 rather, Supreme Court. Peter will be 137 posts. Top trends, those are among the top trends. The PPT judgment is 66.2 thousand posts. Trending in Nigeria, 25% FCT is also top on the post. Justice Samani is amongst the top trends today. But everyone wants to know what the judges are saying. Indeed, the APM case struck out into said, the judges said, I'm paraphrasing here, not their words exactly. It looks like as though they're interfering in another party's matter when it comes to double nomination, and then that the Supreme Court had settled the matter of double nomination, besides the fact that they didn't file that case in time. But I'm not here alone. I still have Dr. Titoju here, who's been monitoring what's happening there. You should have seen him scribbling. He was, you know how it is in primary school when you had, is it primary or secondary, when the teacher comes in and says, take notes, bring out your pens and papers, you're taking notes. That's what Dr. Titoju was doing here. So I'm sure he'd have some comments on this judgment. We also have here in the studio joining us Professor Ademola Abbas, who's a professor of international law and global affairs analyst. He's a visiting senior research fellow, University of Reading, UK, former special advisor to the Lagos State Governor on overseas affairs and investment. Thank you for joining us, Professor Abbas.
Thank you very much for having me.
So before we come to you for a fresh perspective, let's find out from the man that was taking the notes earlier. Dr. Titoju, what were you writing?
Well, I was actually following the positions that has been laid down by the Supreme Court via the decision of this of the presidential election petition court. You know, very fundamental. The court went through the objections, took APM's objections, even though it has been, of course, consolidated, the entire petition. Each of those petitions will still be independent of itself. Now, the APM petition was struck out at the preliminary stage. And then the judges went down into the substance and also dismissed it. So it was struck out. Merit was entertained and was finally dismissed. In arriving at the decision at the primary stage, the court found that the issue of double nomination is a pre-election matter. That they don't have jurisdiction to entertain it. And of course, we have legions of authority that when the pre-election matters are brought before the petition. The petitioner, the court, the tribunal, which is the Presidential Election Petition Tribunal, would not entertain such election because they are not issues that are brought up during election.
Okay, so while Dr. Titoju is talking about his take from the judgment of the Election Petition Court, we'll bring you live footage of what's going on within the courtroom. The lawyers are still seated, waiting for the judges who have taken a break to return from their break and then continue. Still have some other judgments that need to be passed. The petition of the PDP and the Labour Party would have to come up next. I can't say which particular order, but we'll get to that as we go along. And I mentioned earlier that we have Professor Abbas. Again, our studio within the court premises is still there live. Our colleagues Chamberlain and Sean will be joining us much later. We also have our correspondents in the court premises and outside the court premises also keeping tabs on what's happening. We'll bring them to you in the course of this conversation. Shola Shwele is there, Ella is also there. But Professor Abbas, the question some people are asking is, why say if you have any grievance, go to court? If these matters had already been settled, going by what the judge said, had already been settled by the Supreme Court, why tell people go to court on the same matter? Is it a question of the lawyers not paying attention of the judgments that have been given before?
Well, thank you very much. It's not necessarily so, but you're right in that question. It's a very fundamental question because I think it's also going to play out in the subsequent judgment the court is going to give. And I say that because even if a court has given a judgment before, it does not mean that the court is bound by that judgment itself. As an example, so number one, you have a distinction between the lower court and the higher court. If, for instance, the high court gives a judgment on a particular issue, the higher court might come and give a different judgment on the same point of law, probably because the lower court errs in law when it made that decision or so. But another thing is sometimes even a higher court itself might give a judgment. Even Supreme Court can overrule itself.
Yes.
And people keep forgetting that. And that is why lawyers cannot presume, or let me say litigants cannot presume that, oh, because there is an existing authority or precedent on this, if I were to go to court, the result would automatically be the same thing. That is a mistake we are making. And I think that can pan out in a lot of issues. And I don't want to preempt certain discussions today. It's going to pan out in a lot of issues. I think I've had an opportunity to speak on this platform before about the fundamental. I remember one of the arguments that was made in the past about Abuja 25% and this and that. And I said, look, even if there is an existing judgment of the Supreme Court on this side, the same court can distinguish another case on the same point and come to a different conclusion. It is completely acceptable.
For clarity, for those who are not lawyers, what would you say that would be based on? Is it based on the judgment of the sitting justices at that point in time, or is it based on maybe newly developed evidence that has come before the judges? What would you think would make that kind of?
A lot of things could be responsible for that. I mean, one is the fact that a court has an opportunity to review its own judgment, as in Roe v. Wade in the U.S., for instance. The court can come back and take another look at a judgment it gave some 10, 20 years ago. Don't forget, the law is not a brooding omnipotence in the sky. And as one of the judges say, the prophecy of what the courts will do are not more pretentious, is what I mean by the law. What it means is that, look, courts are made of human beings. Human beings can make errors. It's normal. And don't forget what this famous judge, the Supreme Court said. He said, we are final, not because we are infallible. We are infallible only because we are final. In other words, he realized that even the Supreme Court itself could be fallible sometimes.
Well, it looks like the justices are back, so we're going back to the appeal court for the continuation of the sitting of the Presidential Election Petition Court.
Elections to take generic size and nebulous. First category consists of those applications seeking to strike out some paragraphs. They are: first, respondents' motion filed on the 19th of April 2023, which essentially sought for the following reliefs. 1. Order striking out paragraphs 60 to 79, 83, 98, and 99 of the petition for being vague, nebulous, and imprecise. After striking out those paragraphs, strike out grounds of petition alleging corrupt practices, failure of the second and third respondents to score majority of votes. 2. Strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition. 3. Strike out prayers 3, 5, Roman 1, and 2, paragraph 102 of the petition, as well as paragraphs prayers 1, Roman 3, 4, Roman 1, 2, and 3, and 4 in paragraph 102 of the petition, and thereafter dismiss the petition with limine to being academic, being an abuse of. Second and third respondents' motion filed on the 13th of May 2023 sought for the following. 1. Order striking out paragraphs 9, 2, 5, 60, 66, 73, 75, 78, 92, 95, 96, and 97 of the petition to be vague, imprecise, generic, and 2. Order striking out paragraphs 80 to 82, 84 to 98 for failure to disclose facts support the ground that the second and third respondents did not score majority of lawful. 3. Order striking out paragraphs 80 to 82, 84 to 98 on the failure to score 25% of the FCT, which cannot be premised on the ground for failure to score majority of lawful. The fourth respondent, on the other hand, filed motion dated 8th of May 2023, seeking for the following: an order striking out this petition for being incompetent and gross violation of paragraph 4, sub 1, sub D, sub 2, sub 7 of the first schedule to the Electoral Act 22. 2. Order of this Honorable Court striking out grounds 2 of the petition and all associated facts contained in paragraphs 20, 2, 33 to 78 of the incompetent. 3. Order of this Honorable Court striking out paragraphs 2, 20, Roman 2, 33 to 78 of the petition for not being in support of any valid ground in the petition. 4. Order of this Honorable Court striking out paragraph 21 to 27, 29 to 100 of the petition for being non-specific, lacking in clarity, generic, nebulous, vague, speculative, and gold digging in contravention of the first schedule to the Electoral Act. In the above applications, all the respondents relied on the provisions of paragraph 4, sub 1, sub D, and sub 2 of the first schedule to the Electoral Act and variously argued that the paragraphs of the petition which they have listed are liable to be struck out for being vague, generic, imprecise, and nebulous. So arguing they relied on several cases which are cited here. By contrast, the petitioners have submitted that the respondents' objection in the listed paragraphs of the petition are not vague, nebulous, sufficiently pleaded. On this point, the petitioners cited several cases which are reproduced here. Petitioners further argued that the facts in Belgore and Ahmed, and Ipiazu and Oti, Ogu and Ekweremadu, Ojuku and Eradua, PDP and INEC and others, and Soga and Iguede, and all other cases cited by the respondents are not the same with the facts of this petition. Those documents were never pleaded by reference or incorporation in those cases. Additionally, petitioners have relied on paragraph 17.2 of the first schedule to the Electoral Act 2022 and argue that the respondents have joined issues with the petitioners on those paragraphs. Having failed to seek for further particulars, they must be taken to have understood the said paragraph. Having failed to seek for further particulars, they must be taken to have understood the said paragraph. They relied on some cases that are reproduced. Now, resolution. I've carefully considered the submissions of the parties and the judicial authorities cited. It is right that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. General principle of law is that such pleadings must sufficiently and comprehensively set out material facts so as to ascertain with certainty and clarity the matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary of the case he is to meet to afford him the opportunity to properly respond to such case. Its aim is to bring to the knowledge of the opposite side and the court all the essential facts. Therefore, it safeguards against element of surprise. This Shodipo versus Lemini Kane, Odom and others versus PDP and others, Alassane and another versus Ishaku, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based on the relief sought by the petitioners, unquote. Subparagraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively, unquote. In addition to the provisions of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019, subject to such modifications as would bring same in conformity with the provisions of the Act. By Order 13, Rule 4 of the Federal High Court Civil Procedure Rules 2019, every party to an election petition shall ensure that governments in their pleadings, and I quote, contain in a summary form the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively. Quote. By subparagraph 4 of that rule, such facts contained in the pleading must, and I quote again, be alleged positively, precisely, and distinctly, and as briefly as is consistent with a clear statement. Quote. The aforementioned provisions contained in the first schedule to the Electoral Act 2022, as well as the Federal High Court's Rules 2019, state the mandatory requirements of pleadings in election petitions. The requirements for clarity and precision of fact required by paragraph 4 of the first schedule to the Electoral Act means that averments must not be vague, ambiguous, or unclear, leaving room for speculation or conjecture, while the requirements of distinctiveness means that each averment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the averments in the petition and ascertaining the allegations being made in the petition. In particular, paragraph 4 sub 1 sub d, relating to the facts of the petition, the grounds on which it is based, and the relief sought by the petitioner have been severally considered and interpreted by the appellate court. In Belgore and Ahmed Supra, the complaint against the averments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general in terms. In that case, the Apex Court specifically held as follows, and I quote, pleadings in an action are the written statements of the parties wherein they set forth the summary of the material facts on which each relied in proof of his claim or his defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded and in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offences in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4 sub 1 sub d of the first schedule to the Electoral Act and or order 13, rule 4 sub 1, 5, 6, and sub 1 of the Federal High Court Civil Procedure Rules 2009, unquote. Indeed, in PDP and INEC, the Apex Court was categorical when it held those, and I quote, on whether the affected paragraphs were rightly struck out. I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election,